Good day, ladies and gentlemen. Welcome back to another What If video. Today's topic is, what if an employee applies for leave to be trained as a traditional healer? Now, what I will be unpacking today is the topic of accommodating cultural beliefs and indigenous customs in the workplace. As we have discussed in a previous video, employers are not obligated to accept 6 certificates from traditional health practitioners. The reason being is that these practitioners are not yet able to register themselves with the Health Professions Council. However, a letter from a traditional health practitioner may be used to help prove an employee's averment that a calling she had received from her forefathers to become a Sangoma is indeed a serious calling in African culture that an employer must take note of. Now, we can't discuss this topic if we don't talk about the Kiewitzkroon country estate matter. Now, although it's not a new case, the judgment still remains relevant in regards to the topic that we are unpacking today. Now, the case in question was not concerned with the question whether or not a traditional health practitioner certificate constitutes a valid 6 certificate. Instead, in this matter, the court dealt with one important question. Is an employer obliged to try to accommodate an employee's request for leave of absence to be trained as a traditional healer, where the absence to be trained or where the period of leave requested is a month? Put differently, practically speaking, you have an employee who applies for leave. The reason for the leave is to attend traditional healer training or to be trained as a traditional healer, and the period of leave requested is 1 month. The question is, are you obliged as an employer to try and accommodate this employee's request? Now, in this current matter, or the Kiewitzkroon matter, the employee was employed as a pastry chef, and she sought permission from her employer to be granted a month's unpaid leave to attend a ceremony for Sangoma training that she had been undergoing. She submitted proof, she submitted a certificate which was issued by a traditional healer and other supporting documents, but her request was then eventually turned down by the employer. The employee decided to still take her leave and went on unauthorized leave and was subsequently dismissed for being absent without leave. The employee took the matter to the CCMA, and the CCMA in short found that her dismissal was substantively unfair, and it held that the employer ought to have shown greater sensitivity towards the employee who truly believed that ignoring the call to be trained as a Sangoma could bring result in harm to her, even death. So the question, said the arbitrator, was whether the employee had a valid reason for her absence, and in terms hereof, she had to satisfy the commissioner that her absence from duty was necessitated by circumstances beyond her control. The employee in this case, ladies and gentlemen, according to the commissioner, believed that she was called by the ancestors to become a Sangoma. Evidence was led in this regard that she truly believed that she could have died if she had continued to work as a pastry chef and disregarded her calling. Because the average person values his or her or their life as more important than anything else and would do anything to save their life, the employee was faced with 2 evils, and she chose the lesser evil. She found herself in a situation of necessity where the only recourse was to break the employer's rule to save her life. And as they say, necessity knows no law. The commissioner concluded that the employee was justified to choose a course that would save her life. In the normal course of events, and according to human experience, any person would have acted like she did to save her life. On the other hand, the evidence also indicated that the employer would not have suffered irreparable harm arising from the employee's absence. The inescapable conclusion which the commissioner arrived at was that the employee's absence from duty was due to circumstances beyond her control, that she was justified to disregard the employer's instruction and attend the Sangoma course, and that the employer's instruction and refusal to grant her unpaid leave was unreasonable, as the consequences thereof would have been to place her life at risk. The commissioner then concluded that the employee's dismissal was substantively unfair and she was entitled to the reinstatement she sought. The employer was not happy with this arbitration award and took the matter to the Labour Court on review. And on the review, ladies and gentlemen, the Labour Court remarked as follows. This case sadly shows what happens when cultures clash in the workplace. On the one hand, we have an employer that was concerned about making money at all costs, and on the other hand, an employee who had visions and had believed that her ancestors were calling her to become a Sangoma. The employer does not regard a calling to be an ancestor as an illness. The employee believes that if she did not heed the calling to become a Sangoma, she would become ill. However, the employee was not sick, and therefore the provisions of the BCA dealing with sick certificates does not apply to this current matter. The employee did not apply for sick leave, but had applied for unpaid leave to complete her training course to become a Sangoma. The ultimate question that needs to be decided is whether the employee's absence from work was justifiable or not. The court then said that it's trite that in assessing the fairness of a dismissal for absenteeism, the following factors are normally considered relevant. 1, the reason for the employee's absence. Number 2, the duration of the absence. Number 3, the employee's work record. And finally, number 4, the employer's treatment of an offence of absenteeism in the past. The court also said that the onus rests then on the employee to tender a reasonable explanation for their absence. The court found that the arbitrator's award, finding that the dismissal is substantively unfair, was reasonable and accordingly could not fault it. The review application of the employer was dismissed and the employee's reinstatement was then upheld. The employer was not happy and accordingly appealed to the Labour Appeal Court, but the court agreed with the CCMA as well as the Labour Court. So the employee at the end was reinstated. There's another case, ladies and gentlemen, that deals with the issue of cultural accommodation, and that matter is Fairy Tales Boutique, trading as, which we know as Baby City, versus CCMA and others. And in this matter, the Labour Court similarly upheld the decision of the CCMA that the employer's decision to dismiss an employee who failed to attend a scheduled stocktake to attend to a funeral of her mother-in-law was unfair and demonstrated an uncaring disregard for the cultural practices of black people and the family circumstances of the applicant. In this case, the employee took care of her mother-in-law. The mother-in-law was ill for some time, and at the time of the employee's dismissal, which she was dismissed for gross insubordination, she had already exhausted her family responsibility leave. In this case, in arbitration, the commissioner then held that the employee is entitled to disobey an employer's instruction where there was a family emergency and the applicant was needed, according to her custom, to make the arrangements associated with an African funeral. The commissioner found further that the employer had not been unduly inconvenienced by the employee's failure to attend the stock taking that weekend, as it was common practice that employees from other stores would be brought in to assist. The commissioner's award was accordingly upheld by the Labour Court and the employee was reinstated. Now, importantly, ladies and gentlemen, what are the lessons that we learn from these cases? Number 1, employers must show sensitivity to and understanding of the cultural practices of employees. Number 2, absence from work to answer a calling from ancestors may, in appropriate circumstances, constitute a justifiable reason for absence from work. And number 3, even if an employee has exhausted their family responsibility leave, the employer should carefully consider requests for leave in circumstances where the taking of leave would not unduly prejudice the employer, but would run counter to the employee's customs and broader family responsibilities. That then brings us to the end of this video. As always, thank you for joining, and if you have any questions in this regard, please do not hesitate to make contact with us. Until next time, bye-bye.